Welcome back to the deep dive. Okay, let's paint a picture. One that's probably all too real for some Florida property owners listening right now. You've got a tenant. Maybe the rent's just forgotten month after month. Or maybe they've decided your property is the perfect spot for, I don't know, a permanent, really loud drum circle that's driving the neighbors crazy. Or maybe it's simpler, just a guest who was supposed to stay a week and is now, well, part of the furniture.
Right. And in those moments, the frustration boils over. You just want them out. The temptation is huge, isn't it? Just change the locks, maybe drag their stuff to the curb.
Absolutely. That gut reaction just solved the problem right now.
And that's exactly what you cannot do. That move, what we call self-help eviction, it's basically, well, it's a one-way ticket to a courtroom, but with you as the defendant.
Yeah.
Florida law is incredibly specific, hyper-technical, really, about how you regain possession. Get it wrong, and your case gets tossed. It's costly, takes forever, just a nightmare.
A nightmare you cause for yourself, ironically. Okay, so that's our mission today then. Let's break down the actual legal playbook. There are different plays, right? Eviction, unlawful detainer, ejectment.
Exactly. And picking the wrong play from the start, that's a critical error. It guarantees you lose time, money, and gain a whole lot of extra stress. We need to know which is which before you do anything.
All right, let's start with the main event, the one most people probably think of. Standard Florida eviction. This is under Chapter 83. I think you said this is like 99% of cases.
Pretty much, yeah. This is your go-to when the key ingredient is present. A landlord-tenant relationship.
Meaning there was a lease or at least an agreement to pay rent at some point?
Exactly. If rent was ever part of the deal, you're almost certainly looking at a Chapter 83 eviction. And it usually boils down to two main reasons. First, the obvious one, non-payment of rent. Simple enough, right? They didn't pay. The show me the money scenario.
Seems straightforward. Rent's due, rent's not paid. Eviction notice.
Well, yes, but here's the first major tripwire. Landlords often think, okay, they owe rent, and they owe for those late fees, and maybe for that window they broke.
Right. You want to claim everything they owe you, it makes sense. Put it all in the notice so they know the total damage.
And that impulse, while understandable, can be fatal to your case. When you're doing a non-payment eviction, the 3-day notice has to be legally perfect. And perfect means it demands only the actual past due rent, nothing else.
Wait, really? So no late fees, no utility charges they skipped?
Not unless your lease very specifically defines those charges as additional rent. If it doesn't use that exact language and you include those extra amounts in your 3-day notice, you've just invalidated the whole thing.
Wow. Okay, so trying to get back that $50 in late fees could cost me months of lost rent because the case gets thrown out. Is it really that strict?
It absolutely is. The courts require you to give the tenant a crystal clear, legally perfect path to cure just the rent default. Adding other amounts muddies the water, and the judges won't allow it. Technical perfection is key.
Okay, lesson learned on the money path. What about the other big reason for eviction? Lease violations or non-compliance? This is for everything else, right? Breaking rules.
Exactly. This is when the tenant is doing something or failing to do something that violates a material term of the lease agreement. And like non-payment, there's a specific way to handle it. Actually, two ways depending on the violation. It depends if the problem is fixable or what the law calls curable. Let's say they got a pet without permission, like a small dog, or maybe the yard's a mess. That's usually curable.
Okay, so something they can actually fix if they try.
Right. In that case, you serve a 7-day notice to cure. It tells them you have 7 days to fix this specific problem. If they fix it, great, the lease continues. If they don't fix it within those 7 days, then you can file the eviction lawsuit.
And what about things that, well, maybe aren't so fixable, like that permanent drum circle we joked about, or the source materials example of the emotional support alligator?
Yeah, those likely fall into the other category, non-curable violations, or things like serious property destruction, criminal activity, things that are so severe or ongoing that fixing them isn't really an option. For those, you serve a 7-day notice of termination. This notice doesn't give them a chance to cure. It just says, you've seriously breached the lease, it's terminated, you have 7 days to vacate.
Got it. So 2 types of 7-day notices depending on whether the problem can be fixed. But let's circle back to something you mentioned earlier, the timing. Especially for that 3-day notice for rent, you said that's critical.
Oh, it's probably the most critical detail and where so many DIY landlords fail. That 3-day notice to pay or vacate requires 3 full business days.
Meaning?
Meaning you don't count the day the notice is served. You absolutely do not count weekend, Saturday or Sunday. And you do not count any legal holidays observed by the clerk of court.
Okay, hold on. Let's walk through that. If I give the notice on a Friday.
Okay, Friday service. You don't count Friday. You don't count Saturday. You don't count Sunday. So day 1 is Monday. Day 2 is Tuesday. Day 3 is Wednesday. Rent would be due by the end of the day Wednesday.
Unless Monday was, say, Memorial Day.
Exactly. If Monday is a holiday, you don't count that either.
Yeah.
Day 1 becomes Tuesday, day 2 Wednesday, day 3 Thursday. People mess this up constantly. They file the lawsuit a day early.
And the whole case gets dismissed on a technicality before it even starts? Oh, that's painful. You just lost probably a week, maybe more, plus court costs, plus still no rent.
And potentially attorney's fees for the tenant if they hire one to point out your mistake. It's a disaster built on simple miscounting. So whether it's the 3-day or the 7-day notice, you wait until that period fully expires and the tenant hasn't paid or moved out. Then you move to step 2.
Which is the lawsuit itself, right? Filing the actual eviction complaint in county court.
Correct. You file the paperwork. Now the speed element kicks in again, but this time for the tenant. Once they are officially served with the lawsuit by a process server or the sheriff.
They have to respond fast, too.
Very fast. They get only 5 business days to file a written answer with the court clerk. Again, weekends and holidays don't count in that 5-day calculation.
5 days is not a lot of time to find a lawyer and figure out a legal response.
It's incredibly tight.
Yep.
And that's by design. It's meant to be a summary procedure. If they don't respond within those 5 days, you, the landlord, can usually get a default judgment pretty quickly.
And if they do respond?
Then it becomes a contested case. They might raise defenses, like you calculated the rent wrong or the property has issues. Often the judge will order the tenant to deposit the rent they admit owing into the court registry while the case proceeds. But the key is that 5-day response window.
Okay, so notice served correctly, lawsuit filed, tenant maybe defaulted, or you won at a hearing. We get to the end goal. Step 3, the finale, getting the property back. This involves something called a writ of possession.
That's the magic document at the end. If you win, the judge signs the writ of possession. This is basically the court order telling the sheriff to put you back in possession of your property.
So the judge gives it to the sheriff, not to the landlord.
Correct. It goes directly to the sheriff's department. Their civil division handles evictions. The sheriff then goes out and posts another notice on the tenant's door. This one is usually a 24-hour notice.
A final warning.
The final warning.
Okay.
It says the sheriff will be back in 24 hours to remove them. And this next point is absolutely crucial. We have to stress this.
Okay.
After that 24-hour notice expires, only the sheriff or their deputy has the legal authority to physically remove the tenant and their belongings. The landlord cannot.
So even with the writ in hand, the landlord can't go over there, bang on the door, start moving stuff out?
Absolutely not. That's still self-help even after you've won in court. You have to wait for the sheriff to execute the writ.
Yeah.
If you interfere, you could face legal trouble, maybe even negate the whole process. But law enforcement handle the actual removal.
Crucial clarification. Okay, that covers the standard eviction, Chapter 83. But what about those situations where there isn't a landlord-tenant relationship? The person never paid rent, never signed a lease. You said filing an eviction, then, is the wrong play.
Totally wrong. It basically proves the occupant's point if they argue, I'm not a tenant. You need a different tool. This takes us to the what-if scenarios. Scenario A, unlawful detainer. Chapter 82.
Okay, unlawful detainer. Who is this for? Our source called them the house guest from hell.
That's a pretty good description, yeah. Legally, it's for someone who was initially allowed to be there. They had permission, but that permission has now been revoked and they refuse to leave.
Like the examples we mentioned earlier. The adult child who won't move out, the ex-boyfriend, the friend, crashing on the couch indefinitely.
Exactly those types. The key is there was never an intention to create a tenancy. No rent was expected or paid. They were guests, and now they're overstaying their welcome, legally speaking.
So how does this process differ from an eviction? Do you still serve a notice?
No, and this is critical. You do not serve a 3-day or 7-day notice. Those notices imply a landlord-tenant relationship exists. For unlawful detainer, the trigger is simply revoking permission. Once you've clearly told them their permission to stay is withdrawn and they need to leave, and they don't.
You go straight to court.
You go straight to filing the unlawful detainer complaint. It's still a summary procedure designed to be quick like an eviction, but it's based on a different legal theory, expired permission, not a broken lease.
So for my brother-in-law on the couch scenario, telling him you need to leave by Friday and then filing the lawsuit on Monday if he's still there, that's the path. No 3-day notice needed.
That's the correct path for unlawful detainer. Sending him a 3-day notice would actually confuse the issue and potentially weaken your case. Choose the right tool for the job.
Makes sense. Okay, then there's the third category. The source called this the boss level problem. Ejectment. Chapter 66. This sounds serious.
It is. Ejectment is what you use when the person occupying the property isn't just a tenant or a guest, but someone who is actually claiming some kind of ownership interest or legal title to the property.
Okay, like who? Give me an example.
This could be, say, a squatter who's trying to make a formal claim of adverse possession. Or maybe it's a messy inheritance situation where a co-owner is occupying the property against the wishes of other co-owners. Or even a victim of property fraud, where someone bought the house from a scammer and genuinely believes they own it.
So they aren't just refusing to leave. They're saying, I have a right to be here because I have some claim to ownership.
Precisely. And because it involves a dispute over title or ownership, not just possession, is way more complex. This is not a fast-track process.
What makes it so different procedurally? Why is it the boss level?
Two big things. First, you don't file ejectment in county court like evictions or unlawful detainers. You have to file it in circuit court.
And circuit court handles the bigger, more complex lawsuits.
Exactly. Which means ejectment isn't a summary procedure. It's a full-blown lawsuit. You're looking at extensive discovery depositions, interrogatories, requests for documents. It takes much, much longer, often many months, sometimes years. And second, the goal isn't just getting them out. The primary goal is asking the circuit court judge to officially declare that your title to the property is superior to whatever claim the occupant is making. It's fundamentally a fight about who owns the property.
Definitely not a DIY project then.
Oh, absolutely not. Ejectment requires experienced real estate litigation attorneys. It's complex, it's slow, and it's expensive. It's the last resort when you have a genuine title dispute underlying the possession issue.
Okay, laying it all out. Eviction, unlawful detainer, ejectment. It becomes incredibly clear why you said choosing the wrong path is such a critical failure.
It really is. Imagine filing a standard eviction against someone who should have been handled with an unlawful detainer. Their lawyer just points out there's no lease, no rent agreement, and boom, case dismissed. You've wasted weeks, maybe months, lost rent, paid court fees, maybe their attorney fees.
Only to have to start all over again with the correct legal action. Meanwhile, the person is still in your property.
Exactly. The time and money lost can be substantial. Florida law just puts the burden squarely on the property owner to get the procedure technically perfect from step one.
It really underscores the idea that the Florida process is a minefield of technicalities. That point about the 3-day notice calculation, excluding weekends and holidays, it makes you pause, doesn't it?
It does.
Like, just think how many property owners, maybe doing this themselves for the first time, might accidentally blow up their whole case right at the starting line simply because they miscounted those days around a long weekend.
It happens all the time. That level of precision, that meticulousness, it's not optional, it's required.
So the big takeaway here for any property owner listening who's facing one of these situations, the non-paying tenant, the guest who won't leave, maybe even something more complex.
Don't guess. Don't rely on what you think the law is or what seems fair. And definitely, absolutely, do not try self-help. Don't change that lock. Don't cut the power.
Before you write a single notice, before you file anything, before you even have that really tough conversation sometimes, talk to someone who knows this specific area of law.
Get proper legal guidance. It's the difference between a potentially swift resolution and sinking deeper into a costly, time-consuming mess.
Absolutely. So for that clarity, for that security, especially when dealing with evictions or, frankly, any other complex real estate legal area, things like closings, contracts, maybe litigation over boundaries or title, our source suggests, and it makes sense given the complexity we've discussed, that you should contact Barnes Walker for a consultation.
Getting that expert advice up front can save enormous headaches down the road.
You can find out more about their services, which cover real estate law, closings, contracts, and litigation by visiting their website. That's www.barneswalker.com. Make sure you're running the right legal play from the start. Thank you for joining us for this deep dive into the often confusing world of regaining possession of Florida property.